Welcome to TaxSale Insiders, the latest from TaxSale Resources, bringing you information about tax sales from experts in the industry. We interviewed Donald Dinan of Goetz Fitzpatrick, based in the District of Columbia. Don was instrumental in the statutory changes allowing DC to collect taxes using the Investor Avenue back in the late 90s. He hasn't looked back since and is known as the expert in the DC collection process. So sit back and relax for another episode of TaxSale Insiders, powered by TaxSale Resources.
Everybody, welcome to another episode of TaxSale Insiders. I'm Brian Seidenstiger, CEO of TaxSale Resources, and today we're lucky enough to have Don Dinan with us. He's an attorney from Washington D.C., also highly integral to the National Taxing Association. So we're very lucky to have him. Don, welcome.
Well, thank you, Brian, and thank you for having me on, and it's our pleasure.
Excellent. Well, before we get into the juicy stuff, if you will, I have two favorite questions I like to ask, and one of my favorites is just asking how people get into this industry, because it's a very niche section of real estate that the general public doesn't really even know exists, quite honestly, and so. Give me a little background of how did you fall into tax liens?
And fall in is a good phrase. In the mid 90s, the District of Columbia was basically going bankrupt, and in fact, in 1996, it did go bankrupt, and then Congress, which has power over the District of Columbia, disbanded or suspended city government, took over the city, and put in a control board to run the city, which was just basically the federal government to run the city. And among the reforms that they put in, among the things they did, is they entered into what was then pretty new, a tax lien securitization program. At that time, it had only been done in a couple cities, the major one being Jersey City, by a company called Green Capital, run by Doug Green, who was one of the founders of the NTLA. And it was decided to do a securitization program in the District of Columbia. This real quick securitization is that the city will bundle up, or the municipality, the county, will bundle up all of their delinquent liens, sell them to a statutory trust, in other words, sell them to Wall Street, and then institutional investors, largely pension funds, state union pension funds, but investment banks as well, will buy bonds that are secured by the tax liens. So the city gets its money up front, usually 60 to 70%. Then the trust goes out and collects the taxes, pays off the bondholders 18% interest, and of course pays the lawyers, the services, etc., the cost. And then if there's anything left at the end, it would go back to the city. So at that time, I was practicing law. I worked for the federal government for a number of years, mostly in international trade law. But I was involved in what I'm going to call local politics, local neighborhood politics. And in the beginning of the securitization, Mayor Marion Barry, who many people probably still remember, was still mayor. He's going to end up getting removed by the federal government. he was recently out of jail, by the way, and he got reelected as mayor. And he basically said, does anybody know what this securitization thing is? And I made the mistake of answering. And I said, well, I went to the University of Pennsylvania to Wharton, and I said, we studied it when I was there. I said, that was a number of years ago, and back then, what you studied was General Motor car loans, 2-year car loans, because the most that the computer power could do at the time was essentially a 2-year function. The big thing in securitization is you have to know, you have to be able to compute statistically when people will and how many people will prepay.
Mm-hmm.
And that's somewhat of a complicated algorithm. And we used to do it. We have to go down to the computer lab, and we do little punch cards, and we'd punch out the punch cards and run them through the little slot machine, et cetera, et cetera. And then I think I opined, I said, but I'm sure things have changed now. In the mid 90s, because they had tremendously changed because advances in computer power. Isaac Newton knew the math. Everybody knew the math. It's just how fast could you do the calculations in any real time. So Barry put me in charge, and basically one thing led to the other, and I've been involved in the tax lien world since then.
You stuck your hand up at the wrong time, and you've been stuck here ever since.
Yes, there's an alternative theory that some of my friends remember, that I had actually left the room, and they looked around and said, "Who's not here?"
It's just like a classroom when the teacher asks a question, everyone's trying to look away, and
that's right.
Absolutely, gets called on, right?
Yeah.
Well, we're certainly lucky to still have you in the industry, Don. So obviously a lot of changes in the mid 90s. So in coming out of that, obviously DC ended up getting power back, I guess, back.
Yes. So what happened in the Control Board Act is that if the district balanced its budget 3 years in a row, it would revert back to the city. The home rule would come back in, and since the federal government was running it, they easily balanced the budget 3 years in a row, because being unanswerable to any political pressures or whatever, they just did what they had to do, right. And it was pretty severe, brutal cuts that they made. And then when they returned it to home rule, they essentially put in the person who was running the control board. His name was Anthony Williams. They made him mayor. So he just sort of continued the process. That was in 2000. In 2002, the trust began to wind up its affairs. In other words, it had paid off all the bondholders, and actually had a pretty big residual. The real estate in the mid 90s, you couldn't give a house away in Washington. Real estate basically made a big comeback, because under the control board, Congress just pumped a lot of money. At that time, Congress gave us $200 billion boost, if you will.
Wow.
$100 billion was a way a lot of money back then.
Oh, yeah.
I mean, it still is, but back then it was huge. Now that money went to various functions. The part that really only that came directly to the district was it was about 24 billion. In other words, that it was all done in these large appropriations, and most of the money went to federal government improvements to itself in Washington, in the greater Washington area. But that had the effect of drawing a lot of people into Washington. And of course, property values went up. In 2002, the city passed a law that basically carried on the work of the trust, the Securitization Act, and set up a modern tax lien system. They essentially copied the New Jersey system. Green Capital was from out of New Jersey. Most of the bankers, services, et cetera, were in the Philadelphia, New Jersey area. They were all in central New Jersey, Princeton, Mount Holly, Cherry Hill, and then of course, obviously the city of Philadelphia across the river. And then in 2012, the law was updated, if you will, putting in what many people felt were much needed reforms to largely to protect added protections to the elderly and to homeowners, and to provide more efficient notice systems, more complete notice systems, and as part of that act, to set up support systems so that basically anybody who would make an effort would not lose their home to taxes.
Right.
That they would, now if vacant land, abandoned buildings, people that own apartment houses and don't feel like paying their taxes, then the system can be very efficient against you. But for people, who through bad luck or illness or whenever they get a little behind, to not use the tax lien system to throw people out of their house.
Right.
Those, and that's the law that's still in effect.
Got it. Okay, so it went through a lot of changes, but the bulk of the current system that's now in place was in effect in 2002, correct?
That's correct. Yes.
Okay.
Mm-hmm.
Now that new system, okay, so it had a very different process, prior to the federal government taking over. So coming out of that, so in that 2002 system going forward, is it now? It sounds like it's more of a tax lien system, correct?
Yes. The District of Columbia would be considered a tax lien state, if you will, a tax lien system. It operates City of New York, State of New Jersey, State of Maryland, District of Columbia essentially have analogous systems, and as do other jurisdictions, but just here in the Mid-Atlantic area, and they're really all variations of a theme. They're basically the same type of system.
Got it. Okay, so and we've folks may have watched New Jersey and Maryland, so they may be somewhat familiar with it. But I'll kind of dive into it and correct me where I'm wrong here, Don. So essentially, it's a tax lien system where it's 18% interest on the lien. It's a premium bid. So you're bidding a premium above that lien amount, but that premium does not earn any interest, correct?
That's correct. Yes.
So the effective return essentially is your 18% on that lien amount. You got to take that into account with the premium bid that you are bidding. Now that premium bid that is offered, is that kept by the city, or is that just held and given back? What happens to that?
Well, what happens to that is that if the property is redeemed, if the taxpayer finally comes forward and pays his taxes, and of course he has to pay the interest, the 18%, and there's a penalty, a one-time penalty upon the initial delinquency. If the foreclosure process began, attorney's fees and costs, the city will pay back to the tax investor not only what they paid for the certificate and their 18%, but give them back the overbid, give them back the surplus, as it's called in the District of Columbia. And that's what happens about 98% of the cases. That's about the redemption rate.
Okay.
If nobody comes forward and redeems, and the property and the investor, tax sale certificate holder, successfully forecloses and gets a tax deed, then that's what he gets. In other words, the city keeps the surplus.
Got it. So it's an extra fee you have to pay if you do end up.
Yes, because, of course, then, you're looking at it as conceptually as part of the purchase price,
Right.
so to speak. That's not technically what is going on, but that's how a lot of investors
Look at it.
Look at it.
Got it. Got it. Okay. Now, you mentioned some protections that were put in place for, and I'll just, Don wrote a great white paper, and for those that haven't read it or prefer to read it or want to reference back to something that we're talking about today, it's a great resource. But in there, Don, you mentioned some things about how they've changed that system since then, and so as of today, there's no liens that are less than $2,500 that are sold at that auction. Is that correct?
That's correct. Prior to putting that in, they were literally, well, when it was the control board, I mean, they were selling $100 liens, and all of a sudden, people were looking at thousands of dollars in interest and penalties and attorney's fees because they got $100 behind. So that was a huge change. In other words, you have to be relatively delinquent before they're going to sell the property at the auction, or the tax lien certificate, actually sell the property at the auction. The other changes with the notification systems is that they allowed for what they call pre-complaint noticing, and that is before you file the suit for foreclosure, you have to post the property. You have to post it 90 days before to give a warning to the person that that the property is going to be it's liable for a foreclosure suit to be filed against it. And if that happens, you're going to incur legal fees and costs that you'll be liable for. And this is proven to be very, very effective because the redemption rate, what they call the pre-complaint redemption rate, off of that posting is 20-25%. So it really gets people's attention. Whereas before they just get served with a complaint, and boom, they owe a couple $1,000 attorney's fees, and they don't know what hit them. So that was another one of the reforms that was put in.
Got it. At least give people some notice before they have large amounts of fees that are added on to the amount due.
Yes, and as I said, it really is proven to work because it's really an interim type thing that somebody nails that on your door and says, if you don't do something, all this stuff's going to happen to you. That tends to get people in action.
Right. Got it. All right. I'm going to take a little step back, just to talk a little bit more about how the auction actually, functions. There's more and more auctions across the country going online. Is DC still live, or is it online, or is it moving online?
DC is still live, and there really is no movement to put it online, meaning there's no real discussion in investing in the infrastructure that you need to do an online auction. And it really is, it's done the old-fashioned way. Everybody gets in a big room, and you're given a placard with a number on it. And they start off, you have an auctioneer, and the auctioneer, the city starts, they start in the upper northwest quadrant and work all the way through to the lower southeast quadrant. And they read off the property, the clerk does, and then the auctioneer starts auctioning, and people raise their placards, and the last guy who has his hand up owns it. And then they just click through like that, and that's how they're sold. So it's a little old-fashioned that way. The district is kind of purposely not gone online. A lot of the issues that happen with online auctions, such as in Florida, et cetera, that the district feels that they're just not interested in getting into those type of situations, and would rather just, in quotes, do it the way they've always done it. Do it
Right.
that way.
Got it. And so there's no, I know there's some places in Jersey and other parts of the country who have had that same, historically had that same kind of, attitude, but the pressures of COVID have pushed them to at least look at or entertain online auctions for a period of time, if not permanently. But right now, DC is not looking at.
No, the district's reaction to COVID, our auction is in July, is they just canceled the auction.
Right.
And the plan is that they're going to roll up 2 years of taxes into the 2021 auction. If you ask the CFO, his name's Jeff DeWitt at the moment, that office, by the way, is an independent office in the District of Columbia that was set up by the Congress to sort of keep the sticky fingers away. If you ask him, what are we going to do if we still have COVID in July 2021? And his terse response was, he says, the tax auction is going to be the least of our problems. So the district, fortunately, we were solvent enough that we could do without the auction. And interestingly, those taxes were due March 31st, which is the second quarter tax payments, and they were actually pretty good because COVID hadn't really hit. Most people paid sometime beginning middle of March. It'll be real. Next tax day is September 30th, which is Wednesday. It'll be really interesting to see what happens Wednesday. It'll just be interesting to see what happens Wednesday. Because the district, as probably most people know, we're fortunate, I guess, that we play with a net because the Congress is always there to come rushing to the rescue if anything goes too wrong.
Right. Got it. So they canceled this year's, and they just said, basically have 2 years worth of taxes that they'll auction off next year. So at a minimum, the auction next year is going to be quite a bit bigger than normal, just for the fact that you've got multiple years. And I guess the other variable that goes into that is what is the percentage increase of delinquency, over the coming months compared to normal as well. So the 2021 auction in DC is going to be could potentially be very, very large. Is that accurate?
Yes, and you're right, Brian. It will. I mean, we know the delinquency rate's going up. We don't know how much, but it'll definitely be more than twice. So it'll be 2 years plus, and hopefully at that time we'll also be coming out of the pandemic-induced economic downturn. Housing prices, real estate prices in the district have held up very well.
Mm-hmm.
So it could be some tremendous opportunities to investors the July 2021 auction.
Right.
Because you'll be coming in, there'll be a huge pool of properties, a higher quality pool of properties, I would think, but you would be coming into a stable real estate market and maybe even an increasing real estate market. The thing with the district, it's only 63 square miles, and 15% of which is underneath the river. Will Rogers said, best in real estate, they ain't making any more of it.
No, that's true.
The
That's
district,
true.
it's relatively a very small place, and it's the seat of the federal government, and it creates a demand
Right.
for property.
So it'll be interesting to see what happened next year. I guess a couple other things I took out of your white paper, Don, that I think would be key for folks to keep in mind. One is you definitely have to be registered to do business in DC to even register to bid. The second part that I think is kind of unique for tax lien auctions nationwide is you do have to put a deposit down, a 20% deposit down. So if you plan on bidding, $100,000 at the auction, you have to put $20,000, down. And if you go above that $100,000, they won't let you bid anymore. Essentially, you have to go put more deposit up front. Correct?
Yes, you have to have 20% down, and they won't let you bid over that. They're keeping a separate tally. Well, I mean, what most people do, they basically go into the auction. I mean, they know the properties they're going to bid on.
Mm-hmm.
They have a budget, et cetera, et cetera. So you'll put down maybe 30%, 40% or something, give themselves a cushion. But the district's not afraid of taking your money in that, and you will see literally people will jump out of his seat and rush certified money. There's a side office and re-up themselves in the auction, and you can do that relatively quickly, so you don't miss a lot of the action. But obviously the institutional investors don't do that. I mean,
Right.
They're approaching a much more, and then afterwards you have 5 days to settle up with the district, and you've got to settle up because you forfeit all your money if you don't.
Got it.
They
Lose your deposit.
Yeah.
Now, what happens to the liens that don't sell at auction? Are they just gathered up for the next year, or can you buy them directly from the city after the auction? How does that work?
The way it works is that if the lien doesn't sell, it's bid into the district, which means the district has automatically bought it. the district can then do, well, basically they can do what they want with it. They can, which is what they usually do, is that they'll just hold on to it and offer it for sale in next year's auction.
Okay.
Sometimes it's property that the district develops a public purpose for. They want to make a park, put in affordable housing, etc. And they'll use their lien position to foreclose on the property and to do that public project. Just as an aside, it's a very cheap way, a relatively inexpensive way to do put in things like parks, affordable housing, etc. Because if you're just going to do that with property that other people own, and you're going to take the property, eminent domain, of course you have to pay them under the Constitution fair market value for their property. Whereas if you hold the tax certificate, you can foreclose. And you tend to get a huge different reaction where on the one side you're telling people, including collateral relatives and whoever, to come on down and collect money, as opposed to come on down and write me a really big check. Right. So, and of course, a lot of people don't do that because any property that's bid into the district, it's distressed property. Otherwise, an investor would have bought it. But the district also has a couple other ways they can get rid of the properties, the ones that have bid in, and that is they have two separate type auctions, which are usually held in the fall or the spring. It just depends. Following the July auction, and they're not held every year. In fact, there's really no rhyme or reason. They just wait till they feel they have a critical amount, and they start off with what's called a first come first serve auction. Again, everything's done in person. And the first come first serve, they advertise the liens, et cetera, and literally you go down there, and whoever gets in line first goes first, and who's in line second goes second, and you have to pay the face value of the delinquency, the face value of the lien. But there's no overbid situation.
Okay.
And the things that don't sell at that auction, they have what's known as the special discount auction, which is actually more affectionately known as the junk sale. And at the junk sale, and that's done by bidding. It's just like the July auction, you're holding up, but you don't have to, at the ordinary auction, I should have mentioned this, bidding starts at the face value of the delinquency.
Right.
In other words, if the person owns 2,000, it starts at 2,000. It's 20,000, it starts at 20. At the junk sale, it starts at $100.
Okay.
So it could be a $20,000 lien, and you could buy it for $300. And the purpose of that is to try to get properties that are underwater, upside down, back into productive use. Because what many cities ran into, city of Baltimore had a terrible problem with this, Washington had the same problem, is that you had properties that accumulated $20,000, $30,000, $40,000 in taxes, and the property was only worth $10,000.
Right.
And it even got worse when some of these liens went back to the late 60s. DC, they actually, going back, they cut it off at 1990. You'd have 150,000, the property's worth 50. Well, no one's going to pay $150,000 for something that's worth 50,000. So it just sat there in rubble.
Right.
And of course, all the social ills that abandoned property bring, particularly to a city. So that's the role of the junk sale is, we'll basically give you the property if you'll do something with it.
Got it. Got it. Okay. So it's the whole goal is to get, properties back on the tax roll. And these are all ways of allowing that to happen without properties just sitting there and like you said, social ills that come along with pure abandoned property. Excellent. Well, I'm going to shift directions a little bit and come back to interest and how interest is calculated. Like we already mentioned, on the face value, you earn 18% or 1.5% per month on that face value, and it's 0 on the overbed. But then it's really on the subsequent taxes, which in my understanding in DC, it's quarterly, correct?
No, it's semi-annually.
Semi-annually. Okay. So on that next sub-tax that's due, you have the option of paying that, and you also earn 18% on that sub-tax, correct?
That's correct. And in that way, you can increase your return on your capital. Just to give a quick example is, let's say it was a $6,000 lien and you bid $12,000 for it. So you're getting 18% on 6,000 and 0 on 6. So your rate of return is 9%. But let's say the next year, well, this would be a big property, but just to make the math easy, the $6,000 taxes come up. You pay that $6,000. So now you're getting 18% on 12,000, and you've invested 18,000. So now you're getting the higher rate of return, and in that way you can keep increasing your so you'd be getting 2/3 of 18 would be 12%,
right.
Return up from 9, and you can keep increasing it that way. And for people whose investment strategy is that they're investing for the interest, and remember, 98% of the properties are going to redeem. That's obviously a very key way to increase your rate of return and increase it somewhat significantly. For people who are going in and trying to get that, what they call REO property, where the foreclosure actually goes through the 2%. That's a different investment strategy, and most people will do a blend. But there you're looking for that 1 in 100 that you paid $20,000 at the tax sale, and you get $1 million property.
Right.
Doesn't happen very often, but it happens.
Got it. Okay, so you earn 18% on the face value of the lien. You can earn 18% on that subsequent tax if you pay it. Increase your overall rate. And then how long is the redemption period in DC?
Once the certificate is sold at the auction, you have what is known as a 6-month waiting period. And what that is, and colloquially it's called the 6-month right of redemption. That's not really technically true, but what it means is if you come in and pay your taxes, you redeem in that 6 months, there are no extra costs. Now there will be that 18%, but if you're running in the next 30, 60, 90 days, it's not going to be that big an effective interest. and the certificate holder can take no steps to collect on the certificate in that 6-month period, with the exception that they can pre-post the property and order a title report after 4 months. Now, the city title reports, the reimbursable fees $300 for the posting. It's $50. So that would add $350 to the redemption amount, because the taxpayer has to pay that. So they can do that after 4 months, but other than that, they can't do anything until 6 months.
Okay.
But that ends the waiting period. The taxpayer can redeem at any time through the foreclosure process up until, as they say, the fall of the gavel. So
Okay.
in other words, until the judge literally puts the gavel down. And one of the 2012 reforms is that you now have where the court has to set a redemption date, which is, if you will, your last clear chance, the final, where you tell the taxpayer, okay, I've got all the papers to foreclose, we're ready to roll. You have 30 days, you have to November 30th or whatever, to come in and pay. And if you don't, then, but I mean, the judge can be getting ready to sign the order at 10 a.m. on Monday morning, and if you run in at 9, you redeem the property. So you literally have the right to redeem right up to the end of the foreclosure process.
Got it. Okay. So you can, they call it 6-month redemption period, but a true redemption ability, it goes all the way through follow the gavel, and then you can start that foreclosure process after that 6 months. And then do you have a limit of how long you can?
Yes, you have to file the complaint within 1 year of the date of the certificate. The key date is the date of the certificate, not the date of the auction. So the auction's usually the 2nd or 3rd week in July. It takes them about a month to get the certificates out. So for example, in 2019, which was the last auction, the certificates actually came out August 16th.
Okay.
So you have until August 6th. You can't do anything for 6 months since August 16th, and you can't do it, but you have to file the complaint by August 16th of 2020, in this case. If you do not, so you get a 6-month window to file.
Right.
If you do not file in that 6 months, you forfeit your certificate, which means you forfeit all your money,
including premium and everything.
It's considered, it's never gone to the Court of Appeals, that this is a statute of repose, not a statute of limitations. Statute of limitations, there are exceptions. A statute of repose, there are no exceptions.
Got it.
As they would tell us in law school, if you get hit by a bus crossing the street to go to the courthouse, too bad, on the last day. And the statute of repose. Most people don't cut it that close.
Right. Okay. Now, is there anything required between that, start of, I guess I'll take a step back. So you go to the auction, right? And then a month later, you get issued that certificate. That's the date on the certificate. You've got to wait 6 months till you start foreclosure. Just out of curiosity, that month you got to wait between the sale and the date on the certificate. Do you earn interest in that month, or does it start the day of the certificate?
No, the interest starts the day of the auction.
Okay, so you
it's actually the closing date of the auction. So the auctions usually start Monday and Thursday, so you may have 2 days. You'll miss out 2 days or so.
Okay, so you get roughly 7 months of interest, and then I'm assuming you continue to earn that interest through foreclosure, correct?
Yes,
Okay.
absolutely.
Okay, so so I wait that 6 months. I start the foreclosure process, and then what is can you describe that foreclosure process for us?
Yeah, so the foreclosure process would be started by filing a complaint in the Superior Court of the District of Columbia. Superior Court's the first level trial court in the district. It's a local court. Although its rules of procedure are essentially are very similar to substantially the same as the federal rules of procedure. So people who are familiar with a federal court can move, makes it very comfortable for a lot of out-of-state lawyers or investors, et cetera, because they're coming into a system that's very analogous to what they know. You have to name the record owner, the trustees of any deeds of trust, the mortgagees, and the District of Columbia. The District of Columbia has to be is named as a party in every case, so that they can represent the public interest in the foreclosure process to make sure everything's going according to plan. You have to give notice to all lien holders, all the way down to people who have a lis pendens on the property, a mechanic's lien, another lawsuit against the record owner. You don't have to name them as defendant, but you have to give them notice. It's considered much better practice to name them as a defendant and serve them personally, because if you just give the notice, you're not going to get warrantable deed if it goes all the way through. So almost everybody names everybody that's a lien holder. File the complaint. The court schedules what's known as an initial scheduling conference. That's in normal times. I'm going to speak pre-COVID. The post-COVID is not too much is happening, but yeah. In normal times, and the initial scheduling conference would be about 60 to 90 days. If the defendant shows up, particularly if it's the record owner, the court will basically inquire what their plans are to pay the taxes and how much time they think they're going to need. And then based on their responses, et cetera, we'll set a hearing out 60, 120 days, depending. In that process, many people redeem within that time. And that process can basically continue for 3 or 4 cycles before the patience of the court starts getting exhausted. And the investor, tax certificate holder, can ask for the redemption date. And if that's granted, they can file the motion for judgment. Now, the exception to that, if it's an owner-occupier. And if an owner-occupier shows up, again, the process would start the same way. Oh, by the way, that for the patience level tends to start running out after about 18 to 24 months. Okay. So you're going to be in a position of getting the property, unless there are problems when you have dead heirs and things like that can extend it, but around in 2 years, 2.5 years.
Okay.
Back to the owner-occupier. If an owner-occupier shows up, the district basically is not going to take a property from the owner-occupier. If you show up, If you don't show up, then the system will just crank through. But if you show up, and they have numerous resources to help people pay their taxes. And even the protections go so far at the initial scheduling conference, if the record owner doesn't show up, and it's what we call a class 1 property, which is owner occupied.
Right.
That it's class 1 property, then the court will charge the assistant attorney general of the city who's there. At all the hearings, there are attorneys from various social agencies. AARP always has an attorney there, et cetera, because a lot of the problems have to deal with elderly people who oftentimes, they just don't understand what it is. They put the posting, but they don't understand what it is. And oftentimes the plaintiff, the tax certificate holder, will be charged by the court to go find this person.
Okay.
And to make sure that they understand the process, and to, the court will give them, sign them a lawyer, et cetera. And the quality of mercy there, I mean, that can just stretch out for a while. But for the certificate holder, he or she, I mean, they're making 18%.
Right.
So it's kind of like, well, this can go on forever. I get a bond that pays 18%. It's being paid by the District of Columbia. So, there's no default problem going on here. So that's how the process would work.
Got it. Okay. So you buy the certificate, you got to wait roughly a month before that certificate is assigned and you get a date, right?
Yes.
You got to wait 6 months before you start the foreclosure process. And then once you start that foreclosure process, sounds like it's about an 18 to 24 month period before the court might finally say, okay, enough's enough, assign you a property. So you're looking at roughly 2.5 to 3 years, or 2 to 2.5 years or so, on average, right? Obviously, there's circumstances that make it a lot.
Yes, I mean, we usually tell people that think 3 years if it's going to go to deed. But it could be 2, but I think 3. Usually, the properties that go to deed, there's a reason nobody's showing up
Right.
to pay the taxes, and that gets you into the issue of substitute service. In the District of Columbia, you have to serve everybody under what's called Rule 4, which is personal service, and it's identical to Rule 4 of the Federal Rules of Civil Procedure. So, which means you have to serve them personally. And if you can't serve them, which means you have to find them.
Right.
And if you can't serve them personally, you have to go into what's known as substitute service, and that requires you have to go look for them. You have to then file a motion to use substitute service, that's publication, and tell the court all the things you did to try to find them, and you and then you run into the issue. The reason no one showed up because they're dead. And this usually is like if you have record owners. So then you have to go and try to find the heirs. And again, you have to go through motions practice, publication, due diligence. You basically have to hire a private investigator. And if you can't find any heirs, and then you have to give notice to all the heirs you do find, but then you have to publish against all the unknown heirs. Well, all this takes time.
Right. That could take.
And that can elongate out the REO timeline because, again, in almost every case that's not going to get redeemed, there's a reason nobody showed up. And the reason, in very many cases, is they're dead.
Right. Got it. Okay. So it can go a lot longer than that, roughly 3-year time period, depending on the circumstances. Now, you mentioned, the investors making 18% that whole time. They're also likely have bought a subsequent, taxes and earning 18% on that as well. What about all the other? I mean, there's a lot of. You said it's biannually, right? There's a lot of other subsequent taxes that come up in that time period. Is that all? Does the lien holder pay those and they earn 18% on those? How does that work? Or do they go back to an auction? How does that typically function?
No, as the subsequent taxes come up, the lien holder can keep paying them.
Okay.
And of course, if you pay them, then it doesn't get re-auctioned.
Right.
And that creates actually. It's a good point you bring up, an added incentive to pay the subsequents, because if you don't pay the subsequents, you're going to get they're going to sell it again,
right,
at the auction. And in the District of Columbia, there's no priority of certificate. It's whoever wins the race. So,
okay.
Let's say you own the 2015 certificate, and then somebody buys it at the 2017 auction. You don't have a priority. If he and his lawyer have move a little faster than you do, they're going to get the property, not you. It's not a system that the oldest lien has priority. It's a system of first past.
Got it. So
now that hardly ever happens.
Right.
For the obvious reasons.
Right.
The most obvious being 98% redeemed. So.
Right.
The redemption cures a lot of sins.
So is it a situation where, at some point in that foreclosure process, if you chose not to pay those taxes, and let's assume the other lien holder is a year behind, anyway, right? They started a year late. They're roughly a year behind the process. You're going to have to eventually pay that lien holder plus interest as part of that final foreclosure.
Well, what would happen is the district pays everybody. So what would happen is the taxpayer would go in and would pay the whole bill.
Right.
And then the district would say, okay, lien holder 1 gets this amount that they paid at the auction plus 18% for which they held that amount.
Right.
And lien holder 2 would get their share.
Right. Well, if it doesn't redeem, I guess, how does that work?
If it doesn't redeem, the person who completes the foreclosure process first, to get the deed, they would have to, you get what's called a deed bill.
Right.
Which is you have to pay the district everything else that the district is owed, which is usually the subsequent taxes.
Mm-hmm.
Well, that would include another lien holder.
Okay.
So in other words, you'd have to pay off that lien holder.
And interest, right? So
and interest, right? And it's not uncommon that you'll see negotiations where, which one of us is going to take the property and pay the other one off.
Right.
Some people say, well, I'd rather have the property. The other, well, I'd rather have the 18%.
Right.
The long and short of it is that if it does go to deed, the person getting the deed through the deed bill pays off the other lien holder.
Got it.
Albeit it's done through the city. They pay the city everything that's owed, then the city would pay off that lien holder.
Got it. Okay. Interesting. Okay, so I'm curious how DC works, just because it is at the federal level. Because most states, when I ask, what happens to IRS liens, usually IRS liens stick, right? They're not foreclosed out, with a couple exceptions that I've heard. I don't know what the IRS's opinion on those exceptions would be, but anyway, how at the DC, as part of that foreclosure, if there is an IRS lien, is that foreclosed out and eliminated as part of that foreclosure, or is that retained?
The answer is no. Tax liens in the District of Columbia are super priority liens, which means they have priority over everything. Because the key one that people want to know is mortgages.
Right.
Can you extinguish a mortgage? Can you extinguish the bank? And the answer is yes. And they obviously trump any state lien, any District of Columbia lien. For the federal government, however, they do not extinguish a federal lien. So they do not extinguish the IRS.
Okay.
They don't extinguish. The Department of Commerce has a lien through some, it was a commercial property, some federal grant program, or SBA lien, or whatever. However, there is a process, and this actually is available not just to the district, but to the states as well, that you can write in, you can make a request to that federal agency that they waive the lien.
Okay.
And there's basically a set of forms that you have to fill out, et cetera, et cetera. It's a very formal request. And of course, if they grant that waiver, then you can go forward. If they don't, then you got to pay the IRS.
Right.
And there is a default position, which is if they don't answer you in 6 months, it's deemed that they've granted it.
Okay.
The IRS, they always answer. Where things are different, however, in the District of Columbia, because it's all one big happy family, is that in almost every instance, the IRS waives.
Okay.
And if there's liens held by other government agencies, the IRS, I mean the Department of Commerce or SBA or Treasury Department, whomever, they waive. And,
Okay.
and I'm informed in the IRS that they're a little less generous to the states, but to the District of Columbia, I mean, it really is the right hand and the left hand. I mean, the federal government's paying one way or the other, so
Right.
they almost always waive. I would like to tell a funny story, though, is that we had a case. The Department of Commerce had a development lien to rebuild a market here in the District of Columbia called the Union Market, which is now a very popular rebuilt zone. But the developer that they gave the original lien grant defaulted. And the Department of Commerce, the agency there within the department, they really want their money, and they refused. They refused to waive. And so, of course, the Justice Department has to represent them. So the Justice Department removes to federal court. So now all of a sudden you have a tax lien that's in federal court with the Justice Department on one side and the District of Columbia Attorney General on the other side with the tax lien certificate holders. And it just so happened the judge was Emmett Sullivan, who many people might recognize in these modern times. He's the judge on the Flynn case.
Okay.
And Judge Sullivan looks down and he says, well, he says, in federal court, we get a lot of cases. He says, we don't get too many tax liens, but he says, I do kind of notice that it's the United States suing the United States. He says, why don't you fellas go out in the hall and work this out? But it was just kind of a fun, here he is dealing with national security and antitrust and drug cartels, and we show up and we say, well, we got a tax lien on a abandoned 19th century building that they want to make into a city market.
Yeah, priorities, right?
Priorities, that's right.
Excellent. Well, I guess a couple remaining questions for you, Don. Where at in the process do investors typically engage attorneys? Is that I'm assuming right around that 6-month mark, or is it just prior to that, getting ready for the notices, or when do people typically engage you?
Well, the yes, for people that are going in, smaller investors, local investors, people going in for the first time, sometime within the auction and the end of the 6-month waiting period, they would engage an attorney.
Okay.
For the institutional buyers, they basically have their attorneys and have their attorneys by state. Many of the large funds, use any names, they have a policy. They have to have more than one attorney per state and that's often imposed on them by the underlying investors, i.e. the pension funds, that they want. New York City, I believe it's 4.
Oh, wow.
That they have to have. I could be off by one there, but I think it's, I know it's more than 2. And assuming the relationship is well, these are their lawyers for tax liens in that jurisdiction, on a consistent and constant basis, and of course the large institutional buyers, I mean, they're looking to their lawyers not only to conduct the actual foreclosure process, but to give them advice on what's going on in this. I'll use the district as an example. In the district, what's going on at the city council? Are there any impetus to change, the law? Change? Is there any impetus to change policy? What's going on at the courts, et cetera. So a lot of strategic legal advice as they're making their decisions on how much they're going to invest in, because they're making decisions, national decisions. Okay, going to do this much in Jersey, this much in New York,
right,
this much in Arizona.
They'll engage you before an auction ever occurs to help figure out
right,
how much can I allocate, how does the state work, etc. And then kind of a hiatus, if you will, between then they attend the auction, they buy the liens, they wait till just before that 6-month period, and then they'll reach out to you from there.
Right.
Got it. Okay. I got a little ahead of myself only because we talked about the foreclosure process, and eventually you get a deed. From a title insurance standpoint, does that deed you get at the end of foreclosure, is it insurable? Is that title insurable, or do you have to, in a lot of states, you have to go through a secondary quiet title process in order to get insurable title? Is that you have to go through a process?
Yes, the answer is, and it's because of what I'm going to call that Rule 4 process that you have to serve everybody personally. And again, it's the reason that you want to name all lien holders, right down to the mechanic's lien, as a party, so that person gets personal service. I'm going to use the word personal service or substitute service, Rule 4 service. That the district issues you a deed in fee simple absolute. And the title insurance companies are comfortable enough that the court really has done their due diligence, and that they have satisfied themselves that indeed everybody got served.
Right.
And so, in the Constitution, the Supreme Court uh, does not require personal service to fulfill the constitutional protection against taking of properties. They only require that you exercise the level of due diligence, which is that you take all steps necessary. They're reasonably calculated
Right.
to give notice.
Uh,
But the district's a higher standard. You got to serve them.
right. Got it.
So the title. So yes, you if it goes to REO, you do. The title companies will warrant it. One, because they're extremely familiar with the Superior Court. Superior Court judges are really scrutinizing those motions for judgment on the service, and it's not uncommon that the Superior Court will say, no, I don't think. I think you need to do more. And they'll send you back
Right.
and say, I don't think you searched for the years enough, or I don't think you handing it to someone's 12-year-old daughter in the backyard was service.
Right.
Because it's not. You have to be an adult. But and again, I mean, the title companies, they have their own lawyers who are extremely skilled in this area, and I mean, they'll lead the pleadings. They'll play judge,
Right.
and say, yeah, I think that everybody got served, because they want to make sure that after they insure the property, that somebody doesn't come out of the woodwork and make a collateral
Right.
attack.
Their butt's on the line at that point, right?
Yes, exactly.
Right. Got it. Okay. Well, it's obviously there's a lot to the process. Is there any changes in the foreseeable future to how DC conducts their sale or that foreclosure process, or is it fairly stable at this point, Don?
Well, with one exception, which I think falls into that old cliche. Other than that, how was the play, Mrs. Lincoln? There was nothing really on the horizon for any changes, but of course we have the COVID, the pandemic.
Right.
As I said, all the auctions for 2020, and they actually phrase it all auctions. So there aren't going to be any special auctions this fall. Were canceled.
Got it.
So it's a question: what's 2021 going to bring? For the foreclosure process in the courts, the district, there's no stay for tax foreclosures. There is a stay against mortgage foreclosures, against rent evictions, against debt collection. All those things have been stayed.
Right.
But there's no stay for taxes. District wants the money.
Right.
And and the courts, the Superior Court, they were essentially closed from about March 18th to, I think it was May 19th. They may be off on the date, so a couple days. But they're holding virtual hearings now. But the process is much, much slower.
Yeah.
And of course, in the priority of things to the courts, there are many more pressing issues that come before court than taxes.
Right.
Obviously you have the criminal docket. I mean, just to start off there. So those timelines we talked about we're assuming are going to be lengthened. When I say we're assuming, is that in the 2020 cases, they're not going to have an issue. Scheduling conferences until at least December. Whereas they would have been in, they would have started having them last June.
Right.
And then there's the unforeseeable. I mean, as we come out of this pandemic, as we come out of the Black Plague, feudalism may end. It's hard to predict what issues are going to arise. And I mean, and one could be is that you're going to have a critical foreclosure crisis.
Right.
And obviously the government's going to react to that in some manner. But absent the pandemic, there were no changes, and everything was just working like clockwork. Unlike every other type of collection, tax foreclosures are going forward, and tax evictions, if you will. I mean, they will foreclose on you for taxes.
Mm-hmm.
But the court system has slowed down.
Right.
Albeit they, every 30 days they're opening more and more, and the court system is picking up speed. And redemptions are still going through. Just from our own personal experience, we've had about a third of the cases we filed have already redeemed.
Okay.
And it's because, when you get personally served, when the guy with a badge and a gun knocks at your door and hands you, most people don't just ignore that. And of course, they talk to a lawyer, and the lawyer, essentially tells them, we got to get square.
Right.
Because this bill only 18%, it's like, get better terms on the credit card.
Right. Put it on the credit card if you could, right? Got it. Interesting. Okay. So, pre-COVID, no expected changes, but, kind of a giant question mark right now on timeline, as well as, will there ultimately be any changes resulting from the pandemic, and it has yet to be seen. Excellent. My last and second favorite question to ask, Don, is really more just, straight up front guidance. There's a ton of pitfalls out there in this industry, and investing in liens in general, and not getting, folks in trouble. Is there a top one or maybe two pitfalls or pit holes that you see folks regularly fall into in DC that are easy to avoid?
Well, the number one thing is that they don't do their proper due diligence, and you end up getting a tax lien on a property that's not going to redeem, that's underwater. And then all of a sudden, you realize, and then the courts start putting pressure on you as well to ask for the deed. They won't let you drag this out. This is the sixth time you've been here and no one has shown up 6 times. What are you going to do?
Right.
Or should I just dismiss your case and you lose all your money? But if you ask for the tax deed, the district's going to say, okay, you owe all these past taxes, and you may have to write a check for $60,000 on a property that's worth $20,000. In which case, you're basically going to have to walk away,
Right.
And you lose all your money. That's really the number one pitfall, and before the pandemic, the district's real estate was just red hot. But before it got red hot, let's go back to the aughts, and of course, certainly right after 2008, after the market collapse, that was a real pitfall, and that got a lot of people. The second pitfall is essentially, in my opinion, not taking a proper approach, proper stance to the judicial foreclosure process in the courts. You have to realize, one has to realize, investing in the District of Columbia, that while they are very, very good in supporting the tax certificate holders, tax sale holders, they also, it's a very liberal jurisdiction.
Mm-hmm.
The judges are very liberal. The district's a party to every case, and they're there not to protect you. And the city pays public agencies to be at all those hearings.
Okay.
To provide support. So there's a lot of people, particularly who don't understand and if you understand the process, it's a very pro-investor process. But if you want to come in and act like Simon Legree, then all of a sudden, these wheels of justice can start grinding the other way, and they'll just grind you right up.
Got it.
And the investor who does that is going to rule the day. Those are the two big pitfalls.
Got it. So it's common across the board, doing your due diligence, making sure you understand what you're buying and how much you could ultimately be into this property if you're going to end up with it as REO. And then the second one, which I don't hear as often, but is certainly, bear in mind, what's a good way? Play in the sandbox with the departments, right? It's not take the stance of
yes, because again, the District of Columbia, at least not yet. We're not a state. I mean, it's a city.
Right.
So, like all major cities on the East Coast, we're fairly liberal, and they're not part of a state that may be a little more conservative,
right,
than the city itself is. So you just have to understand the political, and I think this is true anywhere. I mean, you go to Jersey, you go to New York City,
right,
you go to Maryland, and Maryland, it's what county you go to. I mean, you can get away with things in Calvert County that you cannot do in Baltimore City,
right,
in the foreclosure process,
right,
et cetera. So you just have to know the turf.
Right. Right. And play well with others.
Yes. But having said that, I do want to emphasize, if you do that, the district is a very good jurisdiction for investors, as shown by the fact that they've suspended everything in collections in the district but taxes and but tax foreclosures. The district, because the city really relies on the property tax to balance its books.
Yeah. Excellent. Well, Don, I can't thank you enough for allowing us to pick your brain and access that immense amount of knowledge you have in that head of yours, and blessing us with allowing us to ask questions and sharing your insight into really the inner workings of DC auctions. Because no matter how many times you read a white paper or even listen to this video, there's always going to be a little more. So I can't thank you enough for helping us understand.
Okay, well, thank you, Brian. It was my pleasure to talk to you.